it's a shame that the court would even have to say something like that. But can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? Huh. Is Mr. Sprinkle available right now? We can find out. Have him come over here.
Uh-oh. Mr. Sprinkle's in trouble? Mr. Adams said, what happened?
Can I briefly address something before?
Yeah.
Is Mr. Sprinkle in trouble? Might be some of what we talked about yesterday.
Good morning, Your Honor.
Good morning.
I appreciate you forwarding to us the ex parte communications you received from Madam DA Fani Willis.
Mm-hmm.
What? I know he did not say ex parte. Mr. Weinstein.
To us the ex parte communications you received from Madam DA Fani Willis. Mm-hmm. Given the sensitivity and the history in this case of ex parte meetings or maybe communications, would you just please request the state? I understand probably what was behind that communications.
Wow.
And of course, it is great for a boss to buck up an underling who has perhaps been attacked or maligned. But I don't believe that, and I don't think the court does either, that the court should have been copied on that communications, especially one that reads maybe more like a campaign ad with a source story in it than anyway, I just don't believe it was appropriate, and I would just ask you to please ask the state to halt any future communications ex parte they might want to have with this court. That's all I have to say. Thank you, Your Honor.
Yeah, it's a shame that the court would even have to say something like that. But can you all please communicate to everybody in the DA's office to not have any sort of ex parte communications with the court? And y'all may not even know what I'm talking about because I don't think either of you was copied on that email, but Ms. Love was. Ms. Hilton, you were as well?
I do, Your Honor, and I don't know, I know exactly what you're talking about. I think we have a different perception of direct communication with the court, but we will make sure that.
But the court was copied on it. And it could have been an accident, but
and Your Honor,
it should have been careful.
But the state did not have the initial conversation with the court. That was a community member, and it was very much a reply. Also, was not a direct communication with the court, but we understand the court's perspective. We understand what the court is saying.
Oh, excuse me. I just need to take issue with the fact that it wasn't a direct communication from the court. I'm sorry. Excuse me. Can you hear me now? I didn't mean to act like Max Shart. I take issue with any type of suggestion that this was not a direct communication with the court. It went from Madam DA Fani Willis to this court. It was a direct communication to this court. It was inappropriate. It was praising Georgia's RICO statutes to the court, which again was not appropriate, Your Honor.
Jeez.
Frankly, I think it might be a good idea to print out the email and make it a court's exhibit to this record. But I think what Ms. Hilton was just saying was that the original communication was not from the district attorney's office. The original communication was, I don't know who this person is or where in the world they are, but some member of the world, member of the public, emailing Ms. Love directly, but copying several other people, the court included, because of course our email addresses are a matter of public record. And, you know, I basically ignored it and deleted it. But as you all know, because I forwarded the next communication to everybody, the elected DA, Ms. Willis, made a decision to respond and directed that response to Ms. Love, but kept everybody, including the person who had made the original email communication, and the court on her response to Ms. Love. And I believe that to be ex parte,
disgusting.
and that is the reason why, as soon as I read it, I had Ms. Persifield forward it to all counsel, because I don't think that should be going on.
And I certainly appreciated that, Your Honor.
And
Thank
the
you.
court really has ignored entirely the substance of the communication, because the court is not making any decisions based on whether I think the RICO statute is good or bad. That's not what judges do. The legislature enacts statutes. I apply them hopefully correctly.
And I have no
or
concern.
whether anybody thinks any attorney is doing a good or a bad job. I'm just sitting here trying to follow the law.
Yikes.
Yeah, and I'm not concerned about any impact on the court from that communication.
Yeah.
It's just
Fanny,
the
you just
Shouldn't be
communication
happening.
itself.
Tricks again.
Thank
Yeah.
you.
So, Ms. Persifield, if you don't mind printing that out. And I have no idea what court exhibit number we're on, but if somebody can figure that out, we'll number it court's exhibit number, whatever the next one is. Do you know?
Your Honor, our numbering system is broken down by act, which is why we have the different letters. So
Oh, no.
talking about the
Court
court's
exhibits.
I will check that, Your Honor.
We don't know, Your Honor.
I mean, I don't know either, but somebody does. The court reporter, or the last court reporter, maybe. But anyway, we'll get that figured out and make that a court's exhibit. Okay.
Shout out to Thugger Daily. Give it out to Thugger Daily going crazy. Here we go. Oh man, this is getting wild. So, Thugger Daily has it. Fani Willis's ex parte email response saying how proud she is of Miss Love and the YSL prosecution, and sharing a story about how an Uber driver told her he wishes they had Rico where he's from. Oh my God. Here it is. YSL Rico case. What are you doing? Miss Love, please ignore this foolishness. As you know, the elected district attorney is extremely proud of you and believes you to be a huge asset to this office.
Stop the cap.
And our community. You have no chance of losing your job, and your service is greatly appreciated. Folks who have never tried cases will always have nasty things to say. Oh, we're just pointing out the obvious, but all right, Fanny. But while they criticize from the sidelines, they fear the arena. They are not risking life and limb to keep our community safe. What? Let me tell you an anecdote of encouragement this morning. A good friend of mine called this weekend and said she was in an Uber, and the Uber driver randomly began talking about being from Memphis and how much violence there was in Memphis. She said the Uber driver said in Memphis they do not have the ability to do RICO. He said, I am so proud of our DA here in Atlanta and her YSL team. They are not afraid and they are fighting for justice. I tell you this random anecdote to encourage you to brush your shoulders off and to keep your eye on the prize, which will always be justice. Please know that your boss gets 100 nasty messages and 100 nice messages a day. I focus on one thing every day, representing my community, smashing Nathan Wade. Oh, wait, that wasn't in there. My bad. Representing my community in a way that is fair. I am asking you to continue to focus on justice and ignore the haters. I am extremely proud of you. Now go make it an amazing day. Yours in service, Fani T. Willis. Aww. Shout out to Thugger Daily for coming through with the exclusive. This is crazy. Fani Willis big up in Miss Love and saying she's doing an amazing job. This is just a mess. Shout out to Thugger Daily for that. Thugger Daily's got the original email, and what So what they're saying happened is this community member sent this email. And what happened was when Fani Willis responded to this, she CC'd everyone. And this is the initial email. And this is the subject: YSL Rico case. What are you doing, dear Miss Love? I have been watching your behavior for quite some time now, and I'm wondering, how can you be so bad at your Is that Gerard that was in our chat the other day? Oh my gosh. How can you be so bad at your job after all these years of experience? The new judge, who was trying to help you, not as much as Earl Glanville did initially, is fed up with you finally. You are ruining your career and what is left of the reputation of the Fulton County DA's office. Please just rest this case, or you will get into so much more trouble. Maybe you're going to lose your job and will have issues in finding a new one because your unprofessional behavior and your haphazard and unorganized ways of working are on display for everyone to see. Please just do the right thing. You are going to lose the case anyway because you lost the jury about 6 months ago already. God dang, Germany's up in here cooking. And what is eventually going to come out is that Young Thug is innocent anyway. He is not an effing Pablo Escobar. But you are acting like it. Just stop it, please, Miss Love. Kind regards from Germany. Aww. All right, so that we're working backwards a little bit. Again, shout out to Thugger Daily for the exclusive. That's absolutely insane that she would respond to this in that way and CC the entire court on there. Fani is just, it's nasty work. Ashley Merchant is cooking. I mean, the court is under some heat right now. But the state mostly is the one who's under fire. Elizabeth Wright mentioned this in the chat. Thank you for your super chat. I'm going to read this in a second. Again, another one from Thugger Daily. Thugger Daily is cooking as usual. This was sent a couple of days ago from Ashley Merchant. And what does Thugger Daily say? Letter addressed to Miss Love by Ashley Merchant on behalf of Duke. Merchant argues that Quindarius Zachary's material witness arrest warrant was legally improper and wants to ensure that the state does not do the same to Duke. Duke also declines to speak to the state before being called up. What does Ashley Merchant say? Dear Miss Love, I hope you are well. Please allow this to follow up our prior discussions in connection with Mr. Martinez Arnold's testimony in the trial of State v. Williams. Given the state has sought arrest warrants in connection with other witnesses, I wanted to proactively reach out to you regarding the scheduling of Mr. Arnold's testimony so that we may avoid any last-minute scheduling issues and avoid a legally improper material witness warrant issuing for Mr. Arnold. In an effort for full transparency, I am copying the court and known defense lawyers on this communication. This is the right way emails are supposed to be done, right? I understand the state would like to speak with Mr. Arnold prior to him taking the stand at trial, but Mr. Arnold did not agree as part of his plea negotiations to allow the state to interview him. He provided testimony as part of his plea, and the state was free then to inquire of him, and it did. As a result, Mr. Arnold declines the state's invitation to talk with the state again prior to his trial testimony. In connection with his anticipated trial testimony, and as a part of the plea negotiations in December 2022, I requested two things. One, the state honor my leaves as Mr. Arnold's counsel of record. Okay, so Ashley Merchant was representing someone who was involved in this YSL trial, and that the state give Mr. Arnold and me advance notice of his trial testimony so that I could comply with my legal obligations pursuant to Superior Court Rule 17.1. which requires that I provide other courts with at least 7 days notice of any conflicts. To be clear, my continued request for advance notice of the date the state anticipates calling Mr. Arnold is in no way a suggestion that he will not abide by the terms of his negotiated plea. He intends to comply with the terms of his plea, just as Wait, let me make sure I'm in the right spot. Hold on. Just as there we go. I hope you will comply with our agreement, provide me with advance notice of this data testimony. Is that the right spot in the email? It seems like a little bit of a jump. While I have not followed the proceedings closely, I understand that the state recently has sought material witness warrants for certain witnesses, and my belief is that the state has done so without legal authority. Again, state not doing their job. I believe the state's arrest of Quindarius Zachary on September 16, 2024 constituted a false arrest and would give rise to civil action against you and the others who effectuated his arrest. And we know Quindarius Zachary was having a lot of health issues and that whole thing was crazy. But anyway, the order your office presented for Judge Whitaker to sign references an application for arrest warrant for a material witness with the criminal offense OCGA 17790. The statute, however, does not apply to the witness, but only applies to criminal defendants and whether they appear for their own cases. For these reasons, I am writing proactively to ensure that you do not improperly seek a material witness warrant for Mr. Arnold. If you do, we intend to seek all the remedies under the law as I outlined below. And I'll guarantee you, knowing Ashley Merchant and seeing her for this short time, she's not going to play around. She will walk up into Judge Whitaker's court and be like, hey, we got to address this now. Let's get this done. Anyway, as I am sure you understand, there is no mechanism to obtain a material witness warrant for in-state witnesses, but the state recently has sought such warrants for in-state witnesses. Material witness warrants are permitted in 2 instances. And thank you and shout out to Ashley Merchant and Doug Weinstein and a lot of everyone who's on the defense side for explaining things thoroughly, so it makes it easy for us to read. I know you don't have to do this, but it makes it a lot easier for us. So y'all keep up the good work. First, pursuant to power to compel the attendance of a witness as in other criminal cases as set forth in and subject to all of the provisions of Chapter 13 of Title 24. At any location where the court shall conduct a hearing, provided that notice is given at least 24 hours prior to the hearing. A court inquiry may order the arrest of a witness if required to compel their attendance. All right, explains OG. We won't go through that. Explains that a court of inquiry is a court with the criminal jurisdiction of a magistrate to examine an acquisition against a person legally arrested and brought before him or her. The provisions clearly do not provide for the instance of material witness warrant before a superior court conducting a criminal trial. The second instance that a material witness warrant may be issued is when a witness is from without the state. Interesting. The pursuant to uniform, we're not going to read all of that. As Mr. Arnold is not a witness from without the state, this provision also does not provide for any issuance of a material witness warrant for Mr. Arnold. While the court retains the power to compel the attendance of the witness, the power is enforced by the attachment for contempt and not material witness warrant. And then she goes to explain everything there. Clearly, the state has no power to seek a material witness warrant for an in-state witness at a trial before a superior court judge. The only power the state has to compel her former client, the attendance of the witness, is contained in OCGA 241326, which is not applicable at this time since Mr. Arnold is willing to appear even without a subpoena, which apparently was in his plea deal from what she's saying. And then we're going to skip through some of this here. Oh, no. While district attorneys typically enjoy immunity for acts undertaken in connection with the court-related duties, the 11th Circuit Court of Appeals recently denied absolute prosecutorial immunity for a Fulton County district attorney who obtained a material witness warrant from a witness and then failed to recall the witness after the witness testified. Interesting. Therefore, the district attorney did not have immunity for false arrest and confinement of a witness under a material witness warrant. If you choose to ignore the foregoing law and seek material witness warrant for Mr. Arnold, we are putting you on notice of our intent to pursue all remedies provided for false arrest and confinement as outlined in the ClassE decision. We truly hope this is not necessary. Yeah, well, they're going to do everything that that they can. So I wouldn't be surprised if that happens. We'll see. I wish again to make it clear that Mr. Arnold intends to comply with his obligations under his plea agreement, which included his rights against self-incrimination under the Fifth Amendment and the right to have me present in the courtroom with him when he is questioned by the state. I am simply requesting that the state, as it is agreed to do, provide me with advance notice for his testimony and honor his privilege against self-incrimination. Though we have not been able to talk about this in person, given our schedules, I hope that this clarifies my opinion, my position regarding Mr. Arnold's testimony, and I look forward to your anticipated cooperation. Shout out to Ashley Merchant. This is what a good lawyer does. Not like, I'm not going to call any names. I'm just going to say this. Monk Tunk could have used Ashley Merchant, it sounds like, because they did that man super dirty with his plea deal.